Hello and happy Tuesday. My name is Michael Leeserman here with the Trial Guide's tip of the day. It is February 20th, 2024. Our tip today comes from Bill Barton's video, Direct Examination. And here to read it is Bill Barton himself. Welcome, Bill.
Hey, good morning, Michael. Shall we begin? Lawyers think in terms of legal elements. No one else in society thinks that way. You need to have an order for your story, yes, but one that makes sense to the jurors. Now, let me kind of give it to you. Think about the instructions as a canopy, something under which you operate. And within that canopy of the law, which is ultimately the special verdict form, is your report card, which a jury will fill out that will grade how well you do in your direct examination. So within that canopy, you should have your story that's linear, yes, but it doesn't necessarily have to begin at the beginning. You can pick the place, and you want to keep the focus of judgment on the defendant. It's somewhat counterintuitive if you're starting out because we're so client-centered. But that's kind of a dead-end street in an odd way because of defensive attribution where jurors will blame the plaintiff, counterfactual reasoning where they will blame the plaintiff. Look at the perfume she was wearing, her high heels she was wearing when she fell, and on we go. So by keeping the focus of judgment on the defendant, when you tell your story and you go upstream as far as you can to find choices, because negligence is a legal word. What you want is culpability or fault. And when people make choices, there are consequences. They have the benefit of something, often a profit or convenience or self-centered indifference. And there are burdens that are paid by third persons called your client. Now that's framing it, the direct examination in the context of a larger story. So I think this is important and we need to think our way through it. And I would tell you I put a little time into this. I'm going to close with this. About the best book out there is Jim McElhaney, who's now passed on, Trial Guides. And actually within it, he has an entire section, part 6, on direct examination. And I consider it as good as it gets. No disrespect to all of Trial Guides' authorship, because I'm quite a shill for them. But you might consider the purchase of this because I consider it as good as it gets in direct examination. Now, I have one other thing to say. When you come over from doing criminal defense to plaintiff's personal injury work, you really never learn good direct examination skills because often in high-end criminal defense, you don't even put the accused on the stand. So you live off your cross-examination. And one of the thing that plaintiff lawyers must shine at of the 5 attributes, jury selection, opening, direct, cross, and closing, is direct. Because if you don't build a powerful case in chief, I don't give a damn what you've got on cross. But that's not true in criminal defense. Something to think about.
Yeah, that makes a lot of sense. And it strikes me when you're talking about focusing on the story and, only lawyers think about legal elements, that part of our job is really translating the law for the layperson. So especially when you get to closing and indirect, but especially closing when there's the jury charges and we have to translate. So I love what you're saying. Culpability and fault is what everyday non-lawyers use. But then the jury instruction will talk about negligence. So we need to be able to translate that using words like culpability and fault, right?
Yeah. And the way I think of culpability and fault is like blameworthiness, negligence. But the real nexus under there is why. That goes to motive. And if you don't answer that well, you're probably not going to do all that well. If you answer motive well, a lot of things will just fall into place. But you have to be thoughtful about it.
Absolutely. Thank you, Bill, for sharing your wisdom today and for all that you do for us. If you haven't checked out Bill's book, especially his videos also, but it's invaluable. Really. Thank you for giving that to us.
Thank you, Michael.
Let's take a deep breath together. Just be grateful to be alive this Tuesday. May the work that we do today help to reduce the suffering in the world. May it help repair the world. May we fiercely and compassionately advocate for our clients, championing their causes and doing good in the world. I'm going to ring a bell 3 times now. This can take you into a meditation practice, a prayer practice, or just let the sounds pierce you and wash over you and remind you it's Tuesday. Wake up, go out, do good things, and have fun while you're doing it.